Hello and welcome to EPG Pathshala Criminology. This paper is Human Rights and Criminal Justice. Current module is entitled Sentencing Principles, Approaches and Procedures. This is Soumya Rai, Assistant Professor Law, Tata Institute of Social Sciences. The aim of this module is to understand sentencing. After the conviction in criminal prosecution, the event that follows the verdict is called sentencing, that is, the imposition of the penalty. The basic objective of these modules are to understand the various objectives and justification of sentencing, to understand the philosophical approaches to the punishment, to understand the principles and procedures involved in sentencing, to understand the role played by Indian judiciary in the fixation of sentencing in spite of lack of any guidance by legislature. Lastly, to understand the need of required legal reform. In this session, we will be discussing objectives and justification for punishment, philosophical approaches to punishments, procedure of punishment in India, and required reforms in the existing sentencing procedures. Crime and punishment are inseparable and interrelated to the extent that one makes us understand the other. The establishment of guilt beyond a reasonable doubt raises two important questions. Firstly, what ought to be done with the person who has committed the crime? Secondly, the other important question which flows from the first is, what purposes are served by prescribing, imposing or refraining from imposing punishment? Punishment is not just a reaction to a crime, but it is broader perspective, aims and objective, which includes prevention of future crimes and rehabilitation of offenders. Before going into the objectives and justification of punishment, we need to understand the concept of punishment. Professor Hall explains punishment in following points. Punishment is a privation, it is a coercive, it is inflicted in the name of a state. Punishment presupposes rules, their violation, and a more or less formal determination of that expressed in a judgment. It is inflicted upon an offender who has committed harm, and this presupposes a set of value by reference to which both the harm and the punishment are ethically significant. The extent or type of punishment is in some way related to the commission of the harm, aggravated or mitigated by reference to the personality of the offender, his motive and temptations. Punishment thus is an integral part of the society. It is closely connected with crime and is inflicted for the purpose of social control. The goal of criminal punishment flows from the criminal environment in which the activity occurs. Further, to understand the justification behind punishment based on gain and loss of utility by punishment, we need to understand retribution, deterrence, rehabilitation and protection of the society. Retribution means vengeance or repudiation. Retribution rests on the idea of just deserts, that is, it is right for the guilty to be punished. According to Bentham, the desire of retribution is not an individual motive for revenge, but community desire. But Kant argued the only legitimate form of punishment the court can prescribe must be based on retribution and no other principle. Kant says, to be just, the punishment must, so far as possible, equal the offence in kind and degree. Here, proportional can be interpreted in narrow as well as broader sense. In its narrow sense, it means an eye for eye or measure for measure, whereas in broader sense, it involves more than pure attribution, which is also supported by H.L.A. Hart. Kant regards punishment as a matter of justice, and it must be carried out by the state for the sake of the law, not for the sake of the criminal or the victim. He argues that if the guilty are not punished, justice is not done. Thomas Hobbes, Jeremy Bentham and Caesar Beccaria gave the foundation of deterrence theory. The term deterrence possesses two separate aspects, one individual or particular and general or group or collective deterrence. Both of the above aspects involve the belief that the imposition of the penal sanction helps to prevent the repetition of the forbidden act. According to individual deterrence, if sufficiently severe punishment is imposed on the offender, it will deter the particular offender from repeating the same offense or from committing further offenses. On the other hand, general deterrence believes that the imposition of the sentence on an individual will deter others from involving in a crime. That is, punishment to the offender by the state will set an example for others in the general population to not commit the crime. More often, general deterrence has no effect on the society as it is hardly brought to the notice of the society. Critics say that deterrence works only if the offender detects its likelihood of being detected and arrested, and that the consequent punishment will be real, inevitable and unpleasant. Thus, it can be concluded that deterrence works only in an effective and efficient criminal justice system. Social, economic and psychological forces involved in the genesis of the crime has led to a greater emphasis on rehabilitation as the best way to protect the individual criminal from himself and to protect the society from the incidence of crime. The task of reintegrating the individual leads not only in the reformation of the individual but also the remaking of the society. It's undoubtedly noble idea that the offender can be corrected, rehabilitated and reintegrated into the society. But the translation of idea into practice is not that easy, and the major question raised is how to rehabilitate the offender. Packers state that one problem with the rehabilitative idea is that it makes the criminal law a vehicle for tasks far beyond its competence. The purpose of sentencing, whether based on retribution or deterrence or rehabilitative theory, is protection of the society. Whereas retribution theory is based on tangible expression of enforcement of law and vindication of legal order, deterrent theory is based on preventing crime both at individual and group level. Rehabilitation is based on reforming and remaking of individual and society. But how far these objectives are achieved is still a debatable issue. A paradox exists that criminal justice punishment has never been very effective in eliminating or reducing crime. Yet, society believes it has no other means to substitute this punishment. Having appreciated the concept and justification of punishment, now we will look theories of punishment. Traditionally, there are two theories of punishment. One is consequentialist or liberal or utilitarian approach, which focuses on crime prevention, and other is deontological or absolute or retributive, which focuses on penal deserts. Whereas consequentialist theory is concerned with effect of punishment, deontological is concerned with moral consideration. The utilitarian approach focuses on the community, that is, good that might follow from punishment and ignoring the justice, whereas retribution focuses on individual and insists that no man can be punished unless he is found guilty, that is, punishment a requirement of justice. Although the two traditional theories are based on different approaches but are complementary to each other, H.L.A. Hart and John Rawls tried to reconcile both the theories. They tried to reconcile the deontological and utilitarian goals of punishment. They gave the mixed or hybrid theory of punishment. Rawls explains that the judge and the legislator stand in different positions and look into different directions, one for the past and the other for the future. The justification of what the judge does qua judge sounds like the retributive view. On the other hand, the justification of what the legislator does qua the legislator sounds like the utilitarian view. Once the legislator decides to have the law and to assign penalties for the violation, an institution is set up which involves a retributive conception of particular cases. The utilitarian argument helps in the making of the decision that what mechanism should be used for controlling legal or social institutions, and if legal, then what penalties to be imposed. But if once it is decided that the mechanism of control is law, then it has to be decided in a particular retributive form. Hart in 1959 developed synthesis of utilitarian and retributive, that is desert-based approach. Hart in this theory distinguished general justifying aim of punishment, that is reason behind existence of criminal sanction, from the criteria of penalties, that is distribution, means who should be punished and how much. According to his theory, the general objective behind imposition of sanction is crime prevention, placing non-utilitarian limits on the distribution of penalties. Paul Robinson in 1987 suggested the hybrid theory. The theory allows departure from the deserved sentences to prevent certain extraordinary harm and more muddled schemes which will allow certain degree of departure from the ordinal desert's constraints. Having analyzed the meaning of punishment, objectives and theory of punishment, let's now discuss the procedure of punishment. In India, there is no prescribed procedure for the imposition of the sentence. Further, there are no sentencing guidelines for the fixation of a sentence by the legislature or the judiciary. It is the discretion of the sentencing judge. Regarding sentencing, wide discretionary powers are given to the judge in India to carry out the task with sensitivity and creative manner. After the establishment of the guilt, the dilemma of the judge begins. Generally, Indian Penal Code prescribes the maximum sentence to be given, and in some offences, minimum sentence to be given after the establishment of the guilt. This is because of the individualization of the punishment. In a majority of the offences under the IPC, imprisonment as a punishment, the court prescribes the maximum penalty and leaves the infliction of appropriate terms within that set limit to the discretion of the sentencing judge. For some offences, minimum sentences is fixed by the court, and infliction of sentence beyond that is left to the discretion of the judges. Whereas for some other offences, the code prescribes alternatives and the court is free to choose either of them. Hence, the dilemma is regarding what is the appropriate sentence to be awarded within such prescribed limits. The statute is silent on how and in what manner the discretion has to be exercised. Further, the statute is silent on when the fine should be imposed and when imprisonment to be awarded. The other important question which flows is regarding the focus of punishment. That is, what should be the focal point from where the punishment has to be directed and at the same time where it should be limited to. Here section 28 of the Code of Criminal Procedure is important, which states about the sentences which High Court and Session judges may pass. Further, section 53 of Indian Penal Code only mentions the type of punishment which are as follows: death penalty, imprisonment for life, imprisonment, forfeiture of property and fine. In recent times, the objective of punishment took a paradigm shift towards reformation, rehabilitation and reintegration of the offender. This is more important when the offender is young. The Probation of Offenders Act came with the same objective. Probation means a period of proofing or trial. The Act contains elaborate provisions relating to probation of offenders, which are made applicable throughout the country. The Act under Section 4 provides 4 different modes of dealing with youthful and other offenders in lieu of sentence, subject to certain conditions. Moreover, under Section 18 of the Juvenile Justice Care and Protection Act 2015, the Juvenile Justice Board have wide sentencing power taking into account the age of the child in conflict with law. Based on the principle of best interest of child, the sentencing objective is rehabilitation, restoration and aftercare. Thus, generally speaking, the IPC gives much sentencing discretion to the judicial officer. The variation in sentencing is due to varying degrees of the offence and or varying characteristic of the offender himself. Therefore, no two offences or offenders can be identical. Theft can be just of ₹100 as well as of million and billions. The varying characteristic of the offender are result of a social, economic and psychological environment. Further, the offender may be first-time offender or a repeated offender, etc. As observed by the Apex Court in Swami Shraddhanand versus the State of Karnataka, there are countless permutations and combinations which are beyond the anticipatory capacity of the human calculus. The charge or label of variation as disparity in sentencing necessarily involves a value-based judgment. That is, disparity to one person may be a simply justified variation to another. The Supreme Court in a number of cases tried to remove this disparity by laying down the guidelines for sentencing. The guidelines involve aggravating and mitigating factors which are not exhaustive, but there are other factors too which are considered by the court while awarding the sentence. In the case of Mullah and other versus the state of UP, the court, while explaining mitigating circumstances, took socio-economic conditions under consideration and observed that we at no stage suggest that economic depravity justify moral depravity, but we certainly recognize that in the real world, such factors may lead a person to crime. Therefore, we believe socio-economic factors might not dilute guilt, but they may amount to mitigating circumstances. Whether sentencing should fit the offence or the offender. The significance of modern sentencing system lies in the individualization of punishment. The Indian Penal Code is an example of the Benthamite philosophy in relation to penal legislation, particularly in the area of punishment. The Benthamite philosophy believes toward rationalization of the sentence. According to it, instead of fitting the offence, the sentence should fit the offenders. According to Professor Sutherland, the evidence in court is designed to show merely the fact of guilt or innocence, but it is entirely insufficient for the purpose of determining what should be done with the individual who is proved guilty. Hence, if the sentence has to be just, it is necessary to know the entire character of the offender and the possible effects of the different methods of dealing with him. In Raviji at the rate of Ramchand versus the state of Rajasthan, the court held that it is the nature and gravity of the crime but not the criminal which are germane for consideration of appropriate punishment in a criminal trial. The court will be failing in its duty if appropriate punishment is not awarded for a crime which has been committed not only against the individual victim but also against the society to which the criminal and victim belongs. Further, in a state of Jammu and Kashmir versus Vinay Nanda, the court observed as under. Where the mandate of law is clear and unambiguous, the court has no option but to pass the sentence on conviction as provided under the statute. The mitigating circumstances in a case, if established, would authorize the court to pass such sentence of imprisonment or fine which may be deemed to be reasonable but not less than the minimum prescribed under an enactment. The Criminal Procedure Code incorporated some provisions such as Section 235 Clause 2 and Section 248 Clause 2, which should be considered to individualize the sentencing process. Section 235 clause 2 of the code says, if the accused is convicted, the judge shall, unless he proceeds in accordance with the provision of section 360, hear the accused on the question of sentence and then pass sentence on him according to law. Further, section 248 clause 2 says, where in any case under this chapter the magistrate finds the accused guilty but does not proceed in accordance with the provision of section 325 or section 360, he shall, after hearing the accused on the question of sentence, pass sentence upon him according to law. The Law Commission in its 47th report identified various issues relating to sentencing process. According to report, a proper sentence is a composite of many factors, which includes the nature of the offence, the circumstances aggravating of the offence, the prior criminal record if any of the offender, the age of the offender, the background of the offender with reference to education, home, life, sobriety and social adjustment, the emotional and mental condition of the offender, the prospect of rehabilitation of the offender, the possibility of return of the offender to the normal life in the community, the possibility of treatment or of training of the offender, the possibility that the sentence may serve as a deterrent to crime by this offender or by others and the present community, need, if any, for such a deterrent in respect to the particular type of offence involved. Awarding a sentence lesser than prescribed in the statute is not a general rule but an exception. Nowhere either in IPC or in any other law in force, any prescription or norm or even guidelines governing the exercise of the vast discretion in the matter of sentencing has been laid down, except perhaps section 354 clause 3 of the Code of Criminal Procedure, which inter alia requires the judgment of a court to state the reasons for the sentence awarded when the punishment prescribed is imprisonment for a term of years. According to section 354(3), when the conviction is for an offence punishable with death or in the alternative with imprisonment for life or imprisonment for a term of years, the judgment shall state the reasons for the sentence awarded, and in the case of sentence of death, the special reasons for such sentence. Thus, the statutory requirement for awarding the punishment less than 7 years is to record adequate and special reasons in writing. In the state of Madhya Pradesh versus Santosh Kumar and in a number of other judicial pronouncements, the highest court held that in order to exercise the discretion of reducing the sentence, the statutory requirement is that the court has to record adequate and special reasons in the judgment and not fanciful reasons which would permit the court to impose a sentence less than the prescribed minimum. In the plethora of judgment, the court tried to explain the meaning of word special and adequate beyond dictionary meaning. In the state of Madhya Pradesh versus Bablu, the apex court observed that undue sympathy to impose inadequate sentence would do more harm to justice system to undermine the public confidence in the efficacy of law. Further, in Meet Singh versus the state of Punjab, the court, while dealing with expression special reasons, held that it means special to the accused concerned. Further, the word special has to be understood in contradistinction to the word general or ordinary. In Kamal Kishore, etc. versus the state of Himachal Pradesh, the court held that the expression adequate and special reasons indicates that it is not enough to have special reasons nor adequate reasons disjunctively. In the state of Karnataka versus Raju, the Honorable Court observed that socioeconomic status, religion, race, caste or creed of the accused or the victims are irrelevant consideration in sentencing policy. Thus, the Indian judiciary in a plethora of cases tried to lay down the guidelines for sentencing by giving value-based judgment, recording the adequate and special reasons, and explaining the factors to be taken care of while awarding a sentence. In India, the government has not yet evolved a sentencing policy, and there is no legislation that provides guidelines in sentencing. The only guidelines available to trial courts are through judgments of the High Court and Supreme Court. In March 2003, the Committee on Reforms of Criminal Justice System, popularly called as the Malimath Committee, in its report emphasized the need to introduce sentencing guidelines in order to minimize uncertainty in awarding sentences. Further, the committee recommended for constitution of a statutory committee to lay guidelines on sentencing. In 2008, the Committee on Draft National Policy on Criminal Justice, popularly known as the Madhav Menon Committee, reasserted the need for statutory sentencing guidelines. Let us now see the situation in USA and UK regarding sentencing guidelines. In USA, several states have introduced guidelines which indicate sentencing ranges according to the type and seriousness of offense and criminal history or antecedents of the offender. There is a permanent sentencing commission to monitor sentencing practice, and an appellate review is provided to determine the propriety of departure from the guidelines. United Kingdom has United Kingdom Criminal Justice Act 2003, which provides the necessary guidelines on sentencing. Thus, there is need of uniform sentencing policy in line with the United States and United Kingdom in order to ensure that judges do not issue varied sentences. At the one hand, we are talking about paradigm shift from deterring towards the reformative, but on the other hand, judgments on fixed sentences is being delivered. This fixed sentencing of life sentence till natural death is limiting the scope of correcting the criminal through therapeutic means. Therefore, it's high time to revisit and rethink the philosophy and justification behind sentencing and its impact on the criminals, victims, as well as society. The existing legislation regarding restitution and compensation should be improved and made more efficient, whereby the possibility of victim and offender reconciliation can be explored. Most cost-effective way of imposing sentences should be explored, which should keep the offender within the society and can fasten the process of rehabilitation and reintegration of the offender in the society. I hope this video gave you the insight of sentencing. For further understanding of the same, you can take the self-assessment and refer suggested readings. Thank you.